Good day, students. Miss Thomas here again. Today is exciting because we have come to the last topic in communication. For the past few videos, we've done many aspects of communication, but today, the aspect that we're going to cover is protecting the artistic and creative work of persons. Some of you all produce artistic work and creative work. Some of you all like songs, stories, drawings, animation. All those are artistic work. Your work, and they belong to you. They're your property. They're your intellectual property first, because you think about it first. When you think about intellect, you think about something going on in the head. And when you think about property, you think about things that belong to you. Do you know those things can be stolen? Do you know that your ideas, and when your ideas come to fruition, can be stolen and they need to be protected? How do we go about protecting these rights, your creative and intellectual property? There are 3 types of legal protection for artistic and creative work. So in the future, or even now, when you're developing your ideas and you're developing your stories and you're developing your games and you're developing all your writings, songs, you have to protect them because there are others who are willing to take them from you. So, the 3 ways that intellectual property and artistic work can be protected is by copyright. We'll get into that just now. Patents and trademarks. I will start with copyright. What is copyright? You hear that word there, right, at the end? It means that you have rights for your intellectual property. The copyright is an exclusive right that is granted to an author or creator like yourself for your original work, including but not limited to the right to copy, distribute, and adapt your work. Copyright laws afford the creators of all those works that I said. Some of the works can be paintings, photographs, motion pictures, sound recording, computer programs, plays, anything like that. It allows you to be the sole, to be the monopoly owner of that creative work. It is yours. It gives you the right, hear that word again, to distribute it, copy it, monetize it, and give it to whomever you want. You have the right to do that. You have the right to collect payment from it. This is your right. It is copyrighted to you. So copyright organizations will grant you, it's like a license to use your work, and it must be only assigned to you. If someone else comes to use your work, they're infringing copyright laws. And of course, there'll be penalties for doing such a thing. And you also must not infringe on copyright laws by using intellectual property that belongs to others. So, for example, you can't use music, take music from somebody else and claim it as your own, or put it into your piece of music and say, oh, this is my piece of work. No. It's the same thing as as plagiarism. I'm sure that you heard that word already in your schooling. Plagiarism. Plagiarism is the unauthorized use or close imitation of the language and thought of another author. So, you're trying to take the work of another author and claim it as your own. So when you're writing your essays or when you're doing any project, it is unlawful to go on the internet and just take things wholesale or go into books and photocopy information or write down information from books that were authored by other persons and then call it your own work. That is called plagiarism. Taking someone else's work and claiming it as your own or trying to represent it as your own. That is called plagiarism, and that is illegal. And of course, you can be fined for such a thing. So copyright laws protect artists like you and others. Of course, most of all the songs that you listen to, they're all copyrighted. You can't just go and take someone else's work and say it's yours. You have to get permission from that person or from the organization that distributed, so you could use their work. Let's take movies, for example. Sometimes we download movies off the internet. That is not correct. That is stealing someone's property. It's called piracy. So be careful downloading music, downloading movies and games. That don't belong to you, especially if you're going to distribute it and sell it to others to make some kind of profit off of someone else's creative work. So copyright laws protect artistic and creative work. Artistic work could be protected. Patents is a set of exclusive rights given by the government to an inventor. So anybody who invents something new, something novel and new and useful, their invention would be patented, meaning it would be assigned and said, yes, this belongs to you. This original work was invented by you, and throughout the ages, it will always be known that you invented this piece of work. Just like the person who invented the light bulb on the telephone, we all know, like William Bell invented the telephone. Throughout the ages, we will know that. Whatever you invent, once it's patented, that honor of knowing who created your work will always go to you and, of course, your family or whoever you assign to continue with your legacy. And the last legal protection that we have is trademarks. Now, trademark is this is a legally registered word or symbols used by manufacturers or sellers to distinguish their goods and services in the marketplace. Some popular ones you know are like the word Coca-Cola or Toyota. You know, that's a car. Persons should not take a Toyota logo and put it on a Nissan logo, on a Nissan car, if you understand what I'm saying. Sometimes we buy knockoff items that might look close to the word Nike or the little tick of Nike. They might call it, I don't know, Pike or Duracell. You know, sometimes you see imitation. Duracell has its original brand, but when persons decide to copy it, they can't use the word Duracell. They have to use, they probably might change up the spelling. So it might be like Luracell. So I'm just being ridiculous. But, you know, they change it up. Because when you see the word Coca-Cola, you should know nobody else could take their drink and call it Coca-Cola. That word or their logo, the Toyota logo or the KFC logo, that's protected. That's their trademark. These trademarks are registered to prevent anybody else, any other manufacturer or seller from using the same sign or symbol or word. So that's just to recap. To protect legal work, we have copyright laws that protect legal work. We have patents, and of course, trademarks. Now, this is just a brief overview. Of course, I know that you're going to continue with your readings. I'm listening to what guidance of your teachers. So that would be it to wrap up communication for the CSEC syllabus for now. And I'd just like to say thank you for watching, and I'll see you in the next video. Bye.